Right, so I'm happy the law applies to you, and that you haven't provided us with any reason to not issue the liability order.
One moment, sir. I can provide you with a very good reason not to issue a liability order.
And what is that?
Well, sir, quite simply they have been paid already in full for the entire year. Sadly, they refused this payment on the 12th May 2010, and then again on the 28th May 2010. I have brought the payment with me to present as proof, sir.
They have already informed you that this is not a valid payment method.
With respect, sir, they have indeed made a statement to that effect. They have, however, failed to validate the statement by providing any proof or reason that the payment is invalid. Is it not true that I can also make statements? I state for, and on the record, that to the best of my knowledge, and having read the Bills of Exchange Act 1882 Section 20, that I have offered valid payment, and they have refused it.
They told you they only accepted cash, check, or card payments.
So far as I can see from the Bills of Exchange Act 1882 Section 20, they were in possession of the payment, and I quote directly from the statute. The person in possession of it has a prima facie authority to fill up the omission in any way he thinks fit. I do not understand how they can say the payment is invalid when it is their decision how they decide to fill it up. If it is invalid, then it would stand to reason it is only invalid is because they have not filled up the omission correctly. Is there a defect in the instrument?
I don't know.
Well, sir, I made a suggestion to them on the 4th June 2010 that they send the payment off to the Under Secretary of the Treasury, and they will be able to create the necessary monies in my account to pay this bill in full. I then instructed them, as trustee, to take this money from my account and use it to zero the council tax account and issue a final statement reflecting the contract and/or agreement is zero. They refused, sir, and sent me the payment back. I would therefore state that so far as I understand it under Section 43 of the Bills of Exchange Act 1882 they are in dishonor, and as such no presentment for payment is now necessary.
The court will be issuing a liability order that Mr. Martin McFly. Mr. McFly must now pay the full amount in council tax for the year 2010/2011. I understand last year there was some confusion over a liability order, so do you understand that one has indeed been granted against you?
I comprehend the words you are saying, sir, but I'm going to need to see a copy of this liability order in order to validate the claim. I have a question about liability orders, sir. May I ask?
If you must.
Thank you, sir. Is there such a thing in law as a group liability order? Or is such an order specific to one person?
A liability order will be specific to one person.
That's very interesting, sir, as last year, sir, the council sent me a group liability order and claimed this to be a liability order. Is it true that this could be understood as an act of fraud, sir?
No, a liability order was granted last year.
I won't take up too much more valuable time, sir, but I need to clarify for the record what has happened today. Is that okay?
If you must.
It's my understanding, sir, that the court has made judgment that 1. The summons sent is lawful despite it not being signed by a justice of the peace or having a wet signature. 2. The Local Government Finance Act 1992 is applicable based only on the council's statement/opinion that it is. 3. A statement has been made that payment of the demand using the method described in the Bills of Exchange Act 1882 is invalid. I understand that the only factual evidence the payment is invalid has been a statement from the council to that effect. 4. A lawful liability order will be issued and sent to me for my inspection. And finally, sir, while we are all gathered in one place and to save time next year, I'd like to ask some very simple questions if I may.
Again, if you must.
Is the demand notice a bill?
They have already informed you it is a demand notice.
But is it a bill?
I suppose so, yes.
Are human beings like myself liable for council tax?
We have established today that the defendant is liable to pay council tax.
With respect, sir, that's not what I asked. I asked if human beings are liable for council tax. Okay, is council tax enforced under a contract law?
You have already been informed it is a civil offense not to pay.
Is it not true that civil matters require a contract, sir? Based on the answers I have received today, then I'd like to say that we could have avoided 1 year of problems and work had the council actually answered my original question in August 2009. Sir, I only required them to issue a statement, and had they have done so, then none of this would have been necessary. I would have continuing paying the debt notes via direct debit. As a reminder, the statement was: human beings, not legal fictions, are lawfully required to pay council tax, and furthermore council tax is not enforced under a contract law. Are they now willing to state that for and on the record at this time? For and on the record, my questions have not been answered, and so I see no alternative but to repeat this procedure until such time as I'm given acceptable answers.